that our people have already received some type of reparations, right?
And I think everybody should read this case.
Yeah, I think they should too.
Yeah,
Now, this case, y'all.
And then any word that you get to, because it's legally, but you're gonna get the picture. But to really understand it, you may have to look up a few terms and words and stuff like that to really understand what it's saying if you're a newbie dealing with law. Because it's a different language, although it appears to be English, it's not. But it's just enough English to get the gist of what they're saying, but it's just enough legalese to confuse you.
Absolutely. And I want to lay this out to everyone again, and I'm going to say this again, that our people, right? Black Americans, American descendants of slaves, foundational Black Americans, whatever we choose to call ourselves, we have already received reparations. And I know it's shocking to hear what I'm saying, but I'm going to prove it based upon this case. All right. Because it's different type of reparations. Now, everyone today is talking about monetary reparations. That, I know what they're talking about. It's about money. But we have received reparations in a certain form. And this case explains it.
Yeah, for the most part, they're talking about money, but how H.R.40 outlines it, they're saying more than money. Like they got a whole list of stuff. He listed a lot about Black scholars, a lot of Black, those who are proponents of it, those who wrote it and part of it in Congress. They talking about more than money, which to me is insane. But go. I just want to put that out there that they're not just solely talking about money, but money is a huge part of it because of our financial disparities.
Exactly. Now, this case is it's Henry American. Sorry about that. It's Henry African American Slave Descendants Litigation, and this case was issued in 2004 in the United States District Court for the Northern District of Illinois Eastern Division. All right, now we're not going to read this entire case. I'm going to skip down to the part that everybody want to hear. And like Rodney said, we encourage you to read this case. We do. But I want to deal with strictly one section because this section covers a lot of ground. All right, here it goes, y'all. Right here. Now I'm gonna start reading from right here and I'm gonna highlight it for you. I just highlighted it. So I'm gonna start right here. I'm gonna highlight this first sentence. It says the Constitution commits to the representative branches, right, of the United States government. Now the representative branches of government will be the executive branch and it will be the legislative branch. Now, how do we know these are representative branches of government? Because these are the individuals that we all elect. So it says the Constitution commits to the representative branches of the United States government the authority to resolve the issue of reparations to former slaves resulting from the nation's role in the institution of slavery. Now, Rodney made that clear earlier when he said that former President Barack Obama, instead of making excuses about why he didn't do anything concerning monetary reparations for descendants of slaves, right? Instead of blaming it on white man, blaming it on white supremacy, right? He could have easily done something with a stroke of a pen with what they call an executive order. Am I right, Rodney?
Yeah, exactly.
But let's keep going. It says, as stated above, historians have long debated whether the issue of slavery was the actual cause of the Civil War. However, regardless of what actually caused the Civil War, it is clear that the abolition of slavery as an institution was a fundamental concern of the representative branches, both during and after the war. Now it goes on and it says, under the Constitution, the war powers are reserved to the representative branches of the government. And it says, see the Constitution, Article 1, Section 8 of the Constitution for the United States of America. Now, it says these powers, right? These powers not only included the power to declare and prosecute war, but also extended to the power to ensure a just and lasting peace following the conclusion of a war. Holding that Congress, right, may reserve the power to seize property following a formal declaration of peace. By exclusivity, entrusting such powers to the representative branches, the Constitution restricts judicial review or interference on many war-related decisions made by Congress and the president, both during and after the war. So again, I already told everybody earlier that the representative branches of government, right, is Congress and the president, right? It's our legislative branch and our executive branch. I made that clear. So now you see the court just explain that to you. All right. Now this case goes on and it says, in this case, there is a strong historical record indicating that the relief sought reparations to former slaves following the Civil War was considered and rejected by the representative branches in lieu of other forms of relief. So again, we're talking about monetary reparations. We already know what everybody wants, monetary reparations, but there was relief that was given. This is what the courts are saying. Now it says this relief came in many forms, including wartime and post-war legislation, civil rights legislation, and constitutional amendments, all intended to ensure the liberty of the newly freed slaves and benefit them generally. For example, prior to the end of the Civil War, Congress passed the Federal Confiscation Act designed to punish those who participated in the rebellion by confiscating their property. Right? And then it goes on right here and it says the Confiscation Act also freed tens of thousands of slaves who had fled to Union forces by the summer of 1862. Shortly thereafter, following a series of Union victories, President Lincoln, using his constitutional authority as commander-in-chief, issued the Emancipation Proclamation on January the 1st, 1863. The Emancipation Proclamation freed all slaves in the states under Confederate control. It says other wartime efforts to ensure the well-being of the newly freed slaves included Congress' creation of the Freedmen's Bureau in March of 1865. Congress created the Freedmen's Bureau pursuant to the war powers to provide former slaves food, clothing, supplies, job placement, educational facilities, and homestead land. The Bureau had the authority to rent or sell to freed slaves land abandoned or confiscated in the Confederacy. Although Congress initially intended for the Bureau's authority to expire 1 year after the completion of the Civil War, Congress voted to extend the Bureau's powers over President Johnson's veto. All right. And right here, it says Congress also passed numerous civil rights acts between the period of 1866 to 1875, specifically the Civil Rights Act of 1866, 1870, 1871, and 1875 were enacted to secure civil rights to the newly freed slaves. Most notably, the Civil Rights Act of 1866 declared, in quotes, all persons to be citizens of the United States and guarantee them legal equality throughout the nation. The act provided that all persons shall have the same right in every state as enjoyed by white citizens. Additionally, Congress ratified 3 constitutional amendments, hereinafter collectively referred to as the Civil War Amendments, between the period of 1865 to 1870 to ensure the liberty of the newly freed slaves. The 13th Amendment, ratified on December 6, 1865, provides in part, neither slavery nor involuntary servitude shall exist within the United States or any place subject to their jurisdiction. So that's the 13th Amendment, Section 1. And then it goes on and it says, this amendment formally abolished slavery within the United States by prohibiting individual states from enacting legislation authorizing the use of slavery within their borders. Noting that the 13th Amendment effectively abolished slavery and gave Congress the power to pass all laws necessary and proper for abolishing all badges and incidents of slavery in the United States. Now, we all know that slavery has been abolished in the United States according to the 13th Amendment unless one is incarcerated. All right, we know this because that's also in the 13th Amendment, but the court isn't addressing that particular clause within the 13th Amendment in this opinion. All right, so I want to make that clear. We know this. Now, the court goes on and they say, Congress then ratified the 14th Amendment on July the 9th, 1868, declaring, among other things, that all persons born or naturalized in the United States were United States citizens and citizens in the state in which they reside. It says Section 1 of this amendment, again, we're talking about the 14th Amendment, effectively overruled the Supreme Court's Dred Scott decision, ultimately making free slave citizens of the United States. So all of these scholars that sit in and want to bring up the Dred Scott case, because I hear a lot of them still do it, and they try to say, well, the Dred Scott case is still in effect. No, it's not. It's been overruled by the 14th Amendment. I didn't say it. The federal court said it. Now it goes on and it says, finally, on February the 3rd, 1870, Congress ratified the 15th Amendment with the intention of granting African Americans the right of suffrage. The 15th Amendment provides, in part, the right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on the account of race, color, or previous condition of servitude. It says, concerned with the possibility that the individual states may attempt to circumvent the purpose behind the Civil War amendments, Congress included an enabling clause in all three of the Civil War amendments, giving it the exclusive power to enforce the amendments with appropriate legislation. All right. Now the court goes on and says, more directly on point, the representative branches considered the issue of reparations, right, to freed slaves for harm suffered as a result of the institution of slavery. Congressman Thaddeus Stevens proposed a bill that would have utilized the Confiscation Act to seize public and private real property within the former Confederate states. And that bill was H.R. 29 of the 40th Congress, Section 1-2, 1867. The confiscated property would have been distributed to the freed slaves. And it says, see Section 4. Specifically, the text of that bill provided, and this is what the text of the bill said, that out of the lands thus seized and confiscated, the slaves who have been liberated by the operations of the war and the amendment to the Constitution or otherwise who reside in said Confederate States on the 4th day of March after death 1861 or since, shall have distributed to them as follows, namely, to each male person who is the head of a family, 40 acres, to each adult male, whether the head of a family or not, 40 acres, to each widow who is the head of a family, 40 acres, to be held by them in fee simple, but to be inalienable for the next 10 years after they come seize thereof. And it goes on and says, in addition, each freed slave would have been entitled to a monetary grant for the purpose of erecting buildings on these distributed lands. And that comes from Section 5, right? Now, Stevens passionately advocated for the passage of this bill. So you're hearing this, right? So we actually did have some white men, right? Namely, that wanted to give us some form of monetary reparations back then. Stevens passionately advocated for the passage of this bill. Stevens indicated that H.R. 29 was designed to help several classes of persons, including free slaves, stating in H.R. 29 is important to 4 million of injured, oppressed, and helpless men whose ancestors for 2 centuries have been held in bondage and compelled to earn the very property a small portion of which we propose to restore to them, and who are now destitute, helpless, and exposed to want and starvation under the deliberate cruelty of their former masters. The cause of the war was slavery. We have liberated the slaves. It is our duty to protect them and provide for them while they are unable to provide for themselves. Have we not a right, in the language of Vital, to do ourselves justice, respecting the object which has caused the war by taking lands for homestead for these objects of the war? Now, right here, it says, according to Stevens, right? And this is in the Congressional Globe, the 40th Congress from 1867. It says passage of H.R. 29 would have served two objectives. First, the bill would have served to punish the Confederate States for their treasonous war. As Stevens stated, you hold at your feet a conquered foe and a atrocious enemy. Tell him on what terms he may arise and depart or remain loyal, but do not embrace him too hastily. Be sure first, sorry about that there is no dagger in his griddle. Second, the bill would have served to place freed slaves on the path to economic independence, as Stevens stated. Now, this is what he stated right here. 4 million people have just been freed from a condition of dependence, wholly unacquainted with business transactions, kept systematically in ignorance of all of their rights and of the common elements of education, without which none of any race are competent to earn an honest living, to guard against the frauds which will always be practiced on the ignorant, or to judge of the most judicious manner of applying their labor. In the Senate, Senator Charles Sumner, right, also championed the vision of land distribution as a form of reparations to freed slaves. According to Sumner, end quote, all who are now familiar with the process of Reconstruction have felt that our work would be incomplete unless in some way or another we secure to the freedmen a piece of land. So again, you had this white guy, right? This white senator that wanted to secure land to our people. You know, you had several of them in Congress that wanted to do this. Now, it goes on and it says, one particular proposed resolution of Sumner's, one particular proposed resolution of Sumner's provided, not less important than education is the homestead, which must be secured to the freedmen, so that at least every head of family may have a piece of land. It says the idea of land distribution was also a plan of the Bureau of Refugee Freedmen and Abandoned Land. However, the idea of land distribution was ultimately abandoned, with President Andrew Johnson pursuing a plan to pardon Confederate sympathizers and restore their property rights. Isn't that interesting? Now check this out. In the words of Senator Sumner, right, lamenting the decision not to extend monetary or property reparations to freed slaves is hauntingly prophetic of this continued post-emancipation reparations movement. In quotes, I don't like to play the part of Cassandra, but I cannot forbear declaring my conviction that we shall regret hereafter that we have not done more. Isn't that interesting? He knew that Congress should have done a lot more. And if Congress would have done a lot more, we wouldn't be having this conversation right now about monetary reparations. We wouldn't. If the freedmen receive land and or money. Now, Sumner also went on and said this, right? It's a statement of Sumner. It says, yet that does not change. Matter of fact, this is the court saying this, right? And before I read this sentence right here, because this sentence is what we all been waiting for, right? Before I read the sentence, I want to show something, right? When I was researching who Charles Sumner is, right? Check this out. Bury Farms. Street names reflect post-Civil War history. Now, Bury Farms, right over there in Anacostia in Southeast Washington, D.C., It used to be, because it don't exist no more. They have neutralized the whole neighborhood. They have tore down the entire Berry Farms. But Berry Farms used to be a notorious neighborhood. This is where a lot of the crime and murders took place at. Am I right, Rodney?
Oh yeah, absolutely.
But I'm right. This is where a lot of the crime took place at.
Absolutely.
Check this out. Charles Sumner. Sumner Road right over there in Berry Farms was named after Charles Sumner. Matter of fact, all of the roads, Pomeroy, Stevens, Howard Road, all of that were named after radical Republicans that had something to do with freeing the slaves. Isn't that interesting?
In other words, these were the white guys who, after slavery, advocated for the betterment of those enslaved.
Exactly. But I don't want to digress. I want to get back to this very important sentence right here. Because again, I made a statement and I said that our people already received reparations. I said that, right? But this is where I got it from. The court goes on and it says, yet that does not change the fact that the representative branches considered the issue of reparations to former slaves, right? They considered the issue of all type of reparations to former slaves. And the chosen vessel of reparations came in the form of constitutional and legislative enactments guaranteeing equality under the law and freedom from discrimination. Did y'all just hear that? I'm going to read that to y'all again. Because again, I'm not saying this. I'm just repeating what the federal court said. The federal court said that our people already received reparations. Now, it wasn't monetary, but they received reparations. And the chosen vessel of reparations, right? Chosen vessel of reparations came in the form of constitutional and legislative enactments guaranteeing equality under the law and freedom from discrimination. So again, I'm making a statement that our people already received reparations. It just wasn't monetary. And the likelihood of receiving monetary reparations is slim. It's not really plausible. But we'll see how this play out.